So Uber's new legal strategy is that riders employ drivers. And all I have to say to this Uber attorney, Theane Evangelis of Gibson Dunn, you're a joke. Pull your damn head out of the sand, or pull your damn head out of your ass. Because as a law professor said, Uber's legal tactics are getting stranger and wilder, right? That stranger and wilder applies to Theane Evangelis. Your arguments are so outlandish, right? For misclassifying drivers, for denying drivers their rights, you should be ashamed of yourself. Gibson Dunn should be ashamed. This is the best you can do at Gibson Dunn as a Los Angeles law firm. I laugh at these damn attorneys, right? And they called Wednesday's argument completely ludicrous. Right? Even the judge is like, you serious? I'm going to read you the story. I am not sure what they were doing there, Gibson Dunn and the attorneys, but to pull this one out of their arsehole, they've got some pretty big balls to try this strategy, right? It's not going to work. It's laughable. It's ludicrous. San Francisco, an Uber lawyer on Wednesday previewed the company's new legal strategy for keeping drivers classified as non-employee contractors, despite a new California labor law that makes it harder to do so. We need to pound these people. We need to out Gibson Dunn in the social media, right? We need to hold these people accountable, right? These attorneys have to be brought before the State Bar of California. And I will also file a complaint against Theane Evangelis for trying to, bend the law so that they can keep us misclassified and deny our rights. It's wrong. It's wrong on every level. Gibson Dunn knows this. Theane Evangelis, you laughing stock. You really are. So last year, California passed Assembly Bill 5, which requires companies to classify workers as employees unless they perform work that is outside the usual course of the hiring entity's business. During a video conference hearing of a lawsuit seeking sick pay for Uber's driver in California, Uber lawyer Theane Evangelis said the new state labor law does not apply to her client because Uber does not hire drivers. Okay? Then the judge asks, who would be the hiring entity then? The U.S. District Judge Edward Chen asked. She answers, the individual consumer who asks for a ride, right? Evangelis replied, it is not Uber who is hiring drivers to perform services for Uber. Reacting to the revelation of Uber's new legal tactics, Stanford law professor William Gould IV said in a phone interview that he believes Uber's positions are getting stranger and wilder. Let me add to that, and more desperate. Right? This is desperation when attorneys reach this level. This one is just completely ludicrous, Gould said. If I buy a ticket to get on a train, am I the employer of the conductor or the ticket agent? Evangelis also revealed Wednesday that Uber plans to demand discovery on whether two named plaintiffs in the lawsuit also drive for Uber's competitor Lyft. She said that will help establish if ride-hail platforms are hiring entities, subject to California's stricter ABC test for determining a worker's employment status. I know firsthand that'll be easy for Evangelis to get because they do work and they are sharing costs on, and I have that information directly from an attorney, that they are sharing costs with Lyft. So they'll get that information like that, right? That's collusion as well. And that in the State Bar of California is not allowed if you're colluding with other attorneys to get an outcome. So completely wrong on every level. Gibson Dunn, you should know that. So Gould said he does not believe that evidence will help Uber in fighting the litigation. There are countless cases where employees work for a number of employees. Gould said that is the modern economy that we live in. At the hearing, Judge Chen appeared equally mystified as to how evidence that drivers work for Lyft and Uber will help the company prevail. Why does it matter if one of these plaintiffs does work for 2 or 3 companies? Chen asked. The reply, Evangelis says, it shows whether these entities are hiring platforms or the extent to them being used simultaneously looking at the Uber app while on a ride they get from Lyft platform, Evangelis said. It's why we think plaintiffs are not employees. Representing lead plaintiff and Uber driver Spencer Verheine's attorney Shannon Liss Riordan, and she's got major settlements from Uber and Lyft before, so she knows the game. She's on the East Coast in Massachusetts. Shannon Liss Riordan blasted Uber's request for discovery as a delay tactic. I can tell you that Uber are masters at the delay tactic. I'm dealing with another Uber fool called Randall Heimovicki, and what they do then is they tell you to get you the documentation, but to win time, they just refuse the delivery. So they try and redeliver, and then they buy time. They don't tell you that, but that's how they operate. They operate in that universe of shenanigans, right? In that universe, that warped, twisted universe of alter reality. They just don't have their shit together. They make crap up as they go along. Oh, it's delay. Here, man. Uber is clearly going to do everything it can to stall out a ruling on this in any way it can, Liz Riordan said. Judge Chen on Wednesday also rejected the plaintiff's request to postpone ruling on arbitration issues. Yeah, hear it now. Don't postpone it, hear it now, which could force most Uber drivers to pursue claims of labor violations through individual arbitration. Beautiful. Citing the judge's position and the fact that only a small number of Uber drivers have opted out of arbitration, Liz Riordan said her clients will dismiss class action allegations and instead seek summary judgment on behalf of two named plaintiffs in the Verheins versus Uber case. Both named plaintiffs opted out of arbitration. Our summary judgment motion will rely on prong B, Liz Riordan said, referring to the second part of the Assembly Bill's 5 ABC test, which says a worker must perform work that is outside an employee's usual course of business in order to be classified as an independent contractor. In March, the plaintiffs filed an emergency motion for a preliminary injunction to make Uber reclassify drivers as employees and provide sick pay. Following an April 1st hearing, Judge Chen ordered both sides to start negotiating a deal to make it easier for drivers to access Uber's financial aid program for COVID-19 affected drivers. On Wednesday, both sides announced that a deal was reached. The plaintiffs withdrew their motion for an emergency injunction, but details of the statement of the settlement remain confidential. So they reached some agreement, Uber and the attorneys, but that's obviously confidential. Also on Wednesday, Chen heard arguments in a related class action, Capriol versus Uber, which seeks an emergency injunction to make Uber provide sick pay to drivers in Massachusetts. The case was transferred from the District of Massachusetts on April the 1st. Chen again ordered both sides to negotiate a deal to expand access to Uber's sick pay type program for drivers in Massachusetts. Uber attorney Evangelis said the company is willing to extend similar terms of the recently brokered deal for California drivers to Massachusetts. They scared. And this Evangelis, you don't have a case here. You can't argue. It's just, it's ludicrous. It's a joke that riders actually employ drivers. You got to just argue the ABC test. It's there, written in stone, and Uber just does not want to pay up, and Uber wants to delay tactics. So we shall see where this goes. But again, Arsehole of the Week award, for me at least, goes to Theane Evangelis for trying.